Good afternoon, everyone. Think about how much time we spend online every day, whether on Instagram, TikTok, WhatsApp, Telegram, or even online games. While these platforms help us to communicate and connect with others, they have also created new opportunities for people to exploit children and teenagers alike. My name is Ryan, and today my group will be discussing the offences found in the Sexual Offences Act Against Children Act 2017, commonly known as the SOCA 2017, which is Malaysia's primary law for protecting children from sexual exploitation and abuse, both online and offline. Understanding this law is important because some actions that may appear harmless online can actually amount to serious criminal offences under Malaysian law. And before we dive into the offences, it's important to first understand why the Act was created. Before 2017, offences involving children were prosecuted under the Penal Code. However, technological developments created new forms of offending, particularly through the internet. Offenders increasingly used social media, messaging applications, and online platforms to groom, exploit, and even abuse children. Now, recognizing these emerging threats, Parliament enacted the SOCA 2017, which came into force on the 10th of July 2017. The Act therefore introduced specific offences aimed at addressing modern forms of exploitation, including child grooming, online sexual communication, and offences involving the exploitive material. In short, the law recognises that child sexual abuse can happen not only in physical spaces, but also through phones, computers, and social media accounts. The first thing you should know is who the law actually protects. Under Section 2 of the SOCA 2017, a child is any person under the age of 18 years. This means that special legal applications and protections apply wherever the victim is below 18, regardless of gender. Whether the conduct occurs face-to-face, social media, through private messages, or through the sharing of images online, the law treats children as a vulnerable group requiring enhanced protection. Some people assume that the offences committed overseas or online are as well beyond the reach of Malaysian law. However, this is not true. In Section 3 of the SOCA 2017, it provides that Malaysian citizens may still be prosecuted in Malaysia for offences committed outside of the country. This is particularly important today because online communication frequently crosses national borders. The law therefore prevents offenders from avoiding liability simply by committing offences overseas. Now, to understand the Act further, it is also important to look at its structure. The Act is divided into several key parts as shown in the diagram above. As I've already discussed Section 2 and 3 of the preliminary, throughout the rest of the presentation, my group members will continue to discuss many of these offences in greater detail. Now, a significant development occurred in 2023 when Parliament passed the Sexual Offences Against Children Amendment Act 2023. Before the amendment, the Act used the term child pornography, and the 2023 amendments formally replaced that terminology with child sexual abuse material, otherwise known as CSAM, and is now the terminology officially adopted in Malaysian law. The amendments reflect Parliament's intention to strengthen the protection of children and better recognize the reality of sexual exploitation in both the physical and digital environments. The change was made because many child protection experts and researchers alike have argued that the term child pornography does not accurately describe the nature of the conduct. Now, when you hear the term pornography, you would often associate it with sexual material involving adults that consent. However, children cannot legally consent to sexual exploitation. The term CSAM is able to more accurately reflect the reality that the materials depict the abuse and exploitation of real-life children. Therefore, the newer terminology adopts a victim-centric approach by recognizing the child as a victim of abuse rather than focusing solely on the content itself. Understanding CSAM is important because it highlights the seriousness of online conduct. An image involving a person under the age of 18 is not merely inappropriate content, but under Malaysian law, it may constitute CSAM and may give rise to serious criminal offences. The term CSAM reminds us that behind every image, is a real child who may have been abused or exploited. As social media, messaging applications, and digital sharing online become increasingly common in this day and age, understanding these risks is essential for protecting both ourselves and other people. Now, with that understanding of the purpose and structure of the SOCA 2017, I will now hand it over to the next presenter, who will further elaborate on what legally constitutes as CSAM. Thank you.
I'm Grace, and I'm going to talk about Child Sexual Abuse Material, CSAM. Before 2017, Malaysia had no specific law on CSAM. Prosecutors could only rely on Section 292 of the Penal Code, a general obscenity provision that was wholly inadequate for child exploitation cases. The turning point was the Richard Huckle case, where a British national abused over 200 Malaysian children, producing and sharing more than 20,000 images online. Sexual Offences Against Children Act 2017 was passed the following year with bipartisan support. CSAM is defined as any representations, whether visual, audio, or written, produced by any means that depicts a child or a person appearing to be a child engaged in sexually explicit conduct. Crucially, this extends to realistic or graphic images, meaning AI-generated content, deepfakes, and computer-animated depictions all fall within the definition. An accused cannot escape liability by arguing that no real child was directly involved in the production. This mirrors the approach taken in the United Kingdom under Section 62 of the Coroners and Justice Act 2009. Sexually explicit conduct is defined to cover both actual and simulated conduct, including sexual intercourse in any form, masturbation, bestiality, sadistic or masochistic abuse in a sexual context, and the exhibition of a child's body for sexual purposes. The inclusion of simulated conduct is legally significant because it removes any argument that no real sexual act occurred during filming. Section 5 is the offense where it criminalizes making, producing, directing, or participating in the production of CSAM, carrying a maximum penalty of 30 years imprisonment and a mandatory minimum of 6 weeks of caning. The word participating gives Section 5 its wide range. A notable example under Section 5 is the case of Dr. Anas Ramli charged in Terengganu in 2024 under Section 5 of SOCA. While treating 5 female pediatric patients aged between 7 and 11 at Kemaman Hospital, he allegedly produced sexually explicit images of those children. In terms of participation liability, this is analogous to common intention under Section 34 of the Penal Code, and prosecutors frequently charge multiple accused persons under Section 5, read together with Section 34 as seen in the Johor Bahru prosecution in July 2025, where 3 individuals were jointly charged for producing CSAM involving 2 teenage victims. Section 6 and 7 extend liability beyond production itself, reflecting the law's preventive purpose. Section 6 criminalizes any preparation to make or direct CSAM, carrying a maximum of 10 years imprisonment and whipping. This is broader than the law of attempt under Section 5.1 of the Penal Code as seen in Munah binti Ali and Public Prosecutor. The High Court held that an attempt under Section 5.1 requires the accused to have moved beyond mere preparation. However, Section 6 sets no such threshold and focuses on preparatory acts relating to the making or directing of CSAM, enabling intervention at an earlier stage than the law of attempt under Section 5.1 of the Penal Code without putting a child under risk. Section 7 criminalizes using a child or causing a child to be used in the production of CSAM while carrying a maximum of 20 years imprisonment and a mandatory 5 strokes. The act's illustration of a father offering his 6-year-old children to a producer in exchange for money, with both the father and producer found guilty. This also reflects a difficult but important legal reality that children are not always victimized by strangers. As ACPAC Malaysia documented in 2022, offenders frequently exploit family relationships to gain access to child victims. In conclusion, Section 5 to 7 of Sexual Offences Against Child Act 2017 created a comprehensive framework that covers every stage from definition to preparation to production, ensuring no participant in the CSAM chain escapes their liability. Thank you.
I am Amita, and I will be advising teenagers on the severe legal implications of transmitting, selling, and accessing child sexual abuse material under Sections 8, 9, and 10 of the Act 792. Teenagers often mistakenly believe that because they did not physically take an illicit photograph, they are safe from criminal liability. This is a profound legal error because in Section 8, it explicitly criminalizes exchanging, publishing, transmitting, or making available child sexual abuse material through any digital medium. This strict public policy is anchored deeply in our criminal law system, as observed in the case of the Court of Appeal civil case of Maslina Ishak versus Muhammad Tahir Osman. Our legal system has a long-standing history of condemning the unauthorized dissemination of non-consensual explicit images under Section 509 of the Penal Code for insulting a person's modesty. Today, Section 8 of Act 792 modernizes this protection. If a teenager forwards an illicit image via WhatsApp, Telegram, or Discord, the actus reus is instantly complete. The statutory maximum under Section 8 is an absolute 15 years of imprisonment, coupled with a mandatory minimum of 3 strokes of the whipping cane. Furthermore, Section 9 tackles commercial exploitation by heavily penalizing anyone who sells or supplies child sexual abuse material directly to a minor, drawing a maximum of 15 years of imprisonment and a mandatory of 5 strokes. This reflects Parliament's strict policy to sever the commercial supply chain within youth networks. Now, let us analyze the single most critical provisions for teenagers navigating today's internet, Section 10, which moves past active sharing and explicitly criminalizes the mere act of accessing or possessing child sexual abuse material. A real-world application of this is Bukit Aman's D11 case, which the data shows that between 2022 and until 2024, the Royal Malaysian Police investigated 238 cases relating to the dissemination and possession of these materials under Section 5 through 10. Under this provision, an offender faces up to 5 years of imprisonment and a fine of up to 10,000 ringgit or both. Accidental versus intentional. Teenagers must understand where the legal boundary of possession is drawn. What happens if a teenager is added to a random group chat and receives unsolicited explicit images? To establish criminal liability under Section 10, the prosecution must satisfy the strict test of actus reus and mens rea, meaning physical control and conscious knowledge. This follows established custody principles in cases like Liao Ngee Lim versus R and the classic standard of R v Warner, which dictate that a person cannot possess something if they are entirely mistaken or ignorant as its true nature. If a teenager unexpectedly opens an attachment, discovers that it contains child sexual abuse material, and immediately deletes the file and exits the chat, the law does not penalize them because there is an absolute absence of guilty mind. However, the moment a teenager hits save to camera roll, backs it up to a file or personal cloud, or keeps it in a stored device, they cross the threshold of intentional retention. The law treats that device storage as an active illegal possession. Predators often rely on digital manipulation to extract these materials, as seen in the case of Sofian bin Yusuf versus Public Prosecutor, where the court firmly rejected the deceptive defenses where explicit photos were taken under false pretenses. Our courts have zero tolerance for possession derived from digital tracks. To demonstrate how serious our legal system takes this section, we have to look at the recent April 2025 judicial controversy. The Human Rights Commission of Malaysia, Suhakam, issued an urgent public advisory critiquing lower courts for handing down mere fines to offenders found with large volumes of child sexual abuse material, urging that the Attorney General Chambers to aggressively appeal for maximum imprisonment under Section 10. This underscores the judicial reality because Section 10 is designed for harsh deterrence and our courts are actively moving away from leniency. As I conclude my part, we see a clear legislative pattern that Act 792 leaves no digital loopholes. It punishes the producer, the distributor, and the consumer. This works directly alongside provisions such as Section 377D of the Penal Code regarding outrages on decency, interpreting through the landmark cases such as Sukma Dawama Samitat. But how does these digital materials become leveraged by predators to target teenagers individually? To answer this, my next member will guide us through the psychology and statutory mechanics of child grooming under Part 3 of the Act. Thank you.
Hello everybody, my name is Adriana and I will continue on with the next part. So while sections 8 to 10 criminalize the production, distribution, and possession of child sexual abuse material, Part 3 of the Sexual Offences Against Children Act 2017 recognizes an equally important reality. Many sexual offenses against children begin long before any physical abuse or explicit image ever occurs. So modern exploitation often starts with conversation, emotional manipulation, and the gradual building of trust. It is this process that the law refers to as child grooming. So Section 11 criminalizes sexually communicating with a child by any means, including words, sound, writings, visual images, gestures, or electronic communication, where the communication is sexual in nature. The offense carries a punishment of imprisonment for a term not exceeding 3 years. The significance of Section 11 is its preventive function. So the law allows intervention before any physical meeting or abuse occurs, recognizing that sexual exploitation may begin entirely online. So in practical terms, this provision captures conduct such as sending sexually explicit messages, requesting intimate photographs, making sexual comments during online conversations, or engaging in repeated sexual discussions through social media, messaging applications, or even dating applications. So research by ECPAT International and UNICEF has shown that offenders frequently target platforms frequently used by teenagers, including Instagram, Snapchat, TikTok, Discord, and online gaming communities, where communication can quickly become private and difficult to monitor. So a particularly dangerous feature of online grooming is the use of false identities. Offenders may pretend to be another teenager using stolen photographs and fabricate common interest to gain a child's trust. So the victim may believe they're communicating with someone that's their own age, when in reality, the offender is a much older adult targeting vulnerable children. Section 12 goes further by criminalizing child grooming itself. A person commits an offense where they communicate with a child with the intention of committing or facilitating a sexual offense against that child. The offense carries a punishment of imprisonment for a term not exceeding 5 years and whipping. Legally, grooming is significant because it is not a single act. Rather, it is a gradual process of manipulation. The offender builds trust, creates emotional dependency, introduces secrecy, and progressively sexualizes the relationship. Psychologists commonly describe grooming as occurring in stages. So first, it's contact, and then there's trust building, emotional bonding, secrecy, and ultimately exploitation. Because the process is gradual, many victims do not immediately recognize that they are being manipulated. So for example, an offender may initially provide emotional support to a teenager experiencing loneliness or family difficulties. They may offer compliments or buy online gifts or gaming currency, or repeatedly tell the child that they are mature for their age. So over time, the conversations become increasingly personal and sexual. The offender may then encourage secrecy by saying things such as, "Our relationship is special," or "Your parents won't understand." Importantly, the law recognizes that this relationship itself causes harm, even before any physical assault occurs. Sections 11 and 12 therefore reflect a broader understanding that child sexual exploitation is often psychological as well as physical. Section 13 criminalizes meeting a child following grooming after prior communication or grooming conduct has taken place. The offense carries a punishment of imprisonment for a term not exceeding 10 years and whipping. The critical point is that liability may arise even before any sexual conduct occurs. Once an offender intentionally arranges or attempts to arrange a meeting following the grooming process, the law intervenes to prevent future harm. This reflects the preventive architecture of SOCA 2017. Parliament recognized that waiting until physical abuse had already occurred would leave children insufficiently protected. Accordingly, the Act criminalizes the preparatory stages of exploitation itself. This is particularly important in the digital era, where offenders may use fake accounts, disappearing messages, encrypted applications, and anonymous online identities to target children across geographical boundaries. Grooming is no longer confined to physical spaces. It is increasingly embedded within the online environments that teenagers use every day. So, to conclude, sections 11 to 13 demonstrate that child sexual exploitation often begins not with physical violence, but with manipulation, secrecy, and psychological control. By criminalizing sexual communication, grooming behavior, and meetings following grooming, SOCA 2017 allows the law to intervene at an earlier stage before abuse escalates further. However, grooming is only one form of exploitation addressed under the Act. The law also recognizes that children suffer direct physical and non-physical sexual abuse, including live-streamed and online sexual performances.
I'm Wenxi, and I'll be presenting Part 4 of the Sexual Offences Against Children Act 2017, Act 792. It consolidates 4 offences: physical sexual assault under Section 14, non-physical sexual assault under Section 15, sexual performance under Section 15A, and sexual extortion under Section 15B. Section 14 criminalizes physical sexual acts against a child without sexual intercourse. This includes touching a child, making a child touch another person, making a child touch themselves, or any other act involving physical contact for sexual purposes. The punishment is imprisonment up to 20 years together with whipping. There are 2 key elements. First, the act must be for sexual purposes. Although undefined, explanation 2 requires courts to consider the body part touched. the nature of the contact, and all surrounding circumstances. In Tai Yun Kong and Public Prosecutor, touching the victim's knee and thigh became sexual when viewed together with the accused masturbating and ejaculating in front of them. Second, touching is interpreted broadly. Explanation 1 states it may occur through any part of the body, an object, or clothing. In Tai Yun Kong, both victims were fully clothed, yet conviction still followed. Section 15 extends liability to non-contact sexual conduct. After the 2023 Amendment Act, paragraph 15 sub B was removed, but the remaining provisions still cover three broad categories: conduct directed at a child, exposing a child to sexual activity, and compelling a child to engage in sexual conduct. Under the first category, Section 15 sub A part 1 criminalizes exposing one's body or any object with the intention that it be seen by a child. In Muniandi Pumalai and Public Prosecutor, the charge failed because the victim did not see the accused remove his towel, showing that intention for the child to perceive the act is essential. Sections 15 sub A part 2 and 3 further criminalize making a child expose themselves and repeatedly following, watching, or contacting a child, including through digital communication. The second category, under sections 15 sub C, D, and E, criminalizes engaging in sexual activity before a child, causing a child to watch sexual activity, or exposing a child to representations of sexual activity, including digitally. The third category, section 15 sub F, criminalizes making a child engage in sexual activity physically, verbally, or electronically. Courts again assess all surrounding circumstances. The punishment under Section 15 is imprisonment up to 10 years or a fine up to 20,000 ringgit or both. Section 15 extends liability to non-contact sexual conduct. After the 2023 Amendment Act, paragraph 15 sub B was removed, but the remaining provisions still cover three broad categories: conduct directed at a child, exposing a child to sexual activity, and compelling a child to engage in sexual conduct. Under the first category, Section 15 sub A part 1 criminalizes exposing one's body or any object with the intention that it be seen by a child. In Muniandi Pumalai and Public Prosecutor, the charge failed because the victim did not see the accused remove his towel, showing that intention for the child to perceive the act is essential. Sections 15 sub A part 2 and 3 further criminalize making a child expose themselves and repeatedly following, watching, or contacting a child, including through digital communication. The second category, under sections 15 sub C, D, and E, criminalizes engaging in sexual activity before a child, causing a child to watch sexual activity, or exposing a child to representations of sexual activity, including digitally. The third category, section 15 sub F, criminalizes making a child engage in sexual activity physically, verbally, or electronically. Courts again assess all surrounding circumstances. The punishment under Section 15 is imprisonment up to 10 years or a fine up to 20,000 ringgit or both. Section 15A was introduced by the 2023 Amendment Act to address child sexual performances, including live stream abuse. It criminalizes offering or making a child available for sexual performance, causing participation, facilitating it, benefiting from it, or even participating as a viewer. Three aspects are significant. First, sexual performance includes sexually explicit conduct performed before viewers, whether live, recorded, or transmitted digitally. Second, even passive viewership is criminalized because the Parliament recognized that demand drives exploitation. Third, liability extends to the entire chain: organizers, intermediaries, viewers, and syndicates. As noted in Hendra bin Maulana and Public Prosecutor, Parliament intended Section 15A to ensure all parties involved in child sexual performances, especially live stream abuse, could be prosecuted. The punishment is imprisonment up to 20 years and a fine up to 50,000 ringgit, the highest penalty in Part 4. In conclusion, Section 14 addresses physical sexual assault, and Section 15 covers non-contact abuse, and Section 15A targets organized and digital exploitation. Thank you. Now, I will pass it on to...
Thank you, Wen-Chi, for setting that crucial foundation on how the Sexual Offences Against Children Act protect minors physically. Members of the floor, as our team's final speaker, my job is to take you into the digital trenches. Our team has shown you how the law protects your physical body. I am here to show you how Sexual Offences Against Children Act protects your digital identity, your reputation, and your mental health. In the next 4 minutes, we will unpack the harsh realities of online sexual extortion, your mandatory legal obligations to report, and the immediate practical steps you must take to protect yourself. Let's start with a term that is commonly terrifying among teenagers today: sextortion. Under Section 15B of the Sexual Offences Against Children Act, this is formally recognized as sexual extortion. This occurs when a predator, whether a stranger via a fake profile or an ex-partner, threatens to leak your private, sensitive photographs, unless you provide them with more images, money, or sexual favors. The law punishes this severely, carrying a maximum sentences of up to 20 years imprisonment and mandatory whipping. Now, to demonstrate the depth of legal analysis, why did Parliament introduce Section 15B when we already have extortion laws under Section 383 of the Penal Code? The answer lies in a critical legal gap. The Penal Code was designed decades ago for traditional blackmail involving money or property. It completely fails to account for the unique, devastating psychological warfare of digital sexual threats against a minor. By separating this into the Sexual Offences Against Children Act, the legislature not only modernized the law for the cyber age, but doubled the criminal penalties. This shows an advanced legal evaluation, recognizing that a teenager, emotional trauma, and loss of dignity is vastly worse than losing material property. Beyond extortion, we must look at contextual offenses where teenagers should feel safe. Incest, though prosecuted under Section 376A of the Penal Code, heavily intersects with Sexual Offences Against Children Act when a child is involved. Ensuring these cases are fast-tracked through specialized child victim court to minimize trauma. Furthermore, Section 15 of Sexual Offences Against Children Act captures non-physical assaults. This means if a predator exposes themselves on a Discord or Telegram video call or compromises your modesty online without physical touch, they are fully liable under this act. This brings us to the heavy responsibility that falls on all of us. Section 19 of Sexual Offences Against Children Act. If a friend confides in you that they are being extorted, you might think keeping their secret is a sign of loyalty. Legally, it is a crime. Section 19 makes it a mandatory legal obligation to report child sexual offences to the police. Failure to do so carries a fine of up to 5,000 ringgit. The law strictly demands that we break the silence to create a collective community safety net. We know that teenagers stay silent out of fear, but the law has evolved to protect you. Under Malaysia's victim protection mechanisms, you will never have to face the predator. You can give evidence via a closed video call from a private room, and your identity is strictly anonymous, and psychological support is provided. This protection is urgent. The PDRM statistics reveal a sharp upward trend in cyber coercion targeting ages 13 to 17, with a rapid rise in male victims as well. Let us anchor this in hard statistical reality. According to administrative records from PDRM and the Department of Statistics Malaysia, total child sexual offences rose by 58.1% over a 3-year span. More alarmingly, non-physical cyber exploitation skyrocketed by a staggering 189.1%. When you pair that with UNICEF and Interpol's finding that 4% of Malaysian teenagers have faced explicit online coercion, the conclusion is clear. Online platforms are now the primary hunting grounds. This statistical explosion is precisely why Section 15B is vital. So, what do you do if you or your friend are targeted? Follow our team's immediate 4-step response protocol. First, stop. Break communication immediately, never pay, and never send more photos, because predators never stop even if you give in. Second, capture. Do not delete the chat out of fear or shame. Take screenshots of their profile, username, bank details, and threats. This is your bulletproof legal evidence. And third, seek. Immediately disclose what happened to a trusted adult, school counselor, or parents. And finally, fourth, report. Lodge a secure report to law enforcement. To wrap up our team's presentation, Sexual Offences Against Children Act 2017 is your live digital shield. Section 15B protects your images, and Section 19 demands we protect our peers, and the specialized courts ensure your safety throughout the legal process. Lock down your privacy settings, never activate webcams with strangers, and save your evidence. If you need help, you can call Talian Kasih at 15999 or message our 24/7 WhatsApp line displayed on the screen. Know your rights, protect your digital footprint, and never let fear keep you silent. Thank you for listening.